Hello and welcome to Prime Time. Today we're talking about English law as an asset, reflections on choice of law after Brexit. Let me start with some housekeeping. This session is being recorded and will be distributed later. Attendees who continue to participate will be taken to have consent to such recording. Attendees are muted and have their video turned off. If you have a question or comment, we'd love to hear from you. Please use the Q&A function to get in touch. You can include your name and affiliation. Questions for the panel will be answered at the end of the session. I'd like to thank FTI Consulting, McCann Fitzgerald and Travis Smith for sponsoring this series of Prime Time. And thank you also to LexisNexis for assistance with promotion. I'm now going to introduce our speakers for today. Unfortunately, Liz Gloucester's unable to join us, but we're proceeding as planned with the rest of the panel. So let me start with Philip Wood, who is both moderating and speaking today. Philip Wood CBE QC on. He's former head of the Global Law Intelligence Unit, Special Global Counsel at Allen & Overy LLP. He's a York Distinguished Visiting Fellow at the University of Cambridge, a former visiting professor at the University of Oxford and Queen Mary University London. He's the author of a staggering 9 volumes in the Law and Practice of International Finance series, published in 2019, and he's a prime finance expert. And next we have Professor Dr. Carl Bardenbacker, Senior Partner at Baudenbacher Law in Zurich and a Door Tenant at Monckton Chambers in London. He's a visiting professor at the London School of Economics. He's president of the EFTA Court from 2003 to 2017, and he's a prime finance expert. And finally, we have Guy Beringer, also CBE QC on. He's chair of the Legal Education Foundation, as well as the Development Board of the Bingham Centre. He's a trustee and director of both Bailey and the National Pro Bono Centre. He's a former senior partner of Allen & Overy, and he's a former chair of UK Export Finance. And I'm Camilla Macpherson, Head of Secretariat for Prime Finance. We're going to start by handing over to Philip to set the scene, and then I'll reappear towards the end of the session as we get to the Q&A. So Philip, it's over to you.
Thank you very much, Camilla, and thank you in particular for the special plug for my books. You know, they really need it. I would give my greetings to everybody who's listening in. I can see there's some very familiar names, and I'm really sorry that I'm not able to resume the many conversations we've had personally in the past with you, but it's very good to see you. This subject which we are discussing today, I must say, within my living memory, has been treated very intensively, quite frequently over the past. It first surfaced for me, at any rate, back in the 70s at the opening of the Eurodollar markets, where there were endless conferences about the governing law and the pros and cons of the choice for the new Eurobonds and syndicated credits and things like that. And then the next time when the discussions resumed again was at the time of the Greek bankruptcy, when there was a contest between a Eurozone system of law and English law for the Greek law bonds, when all of the issues sort of were gone through again. And then finally, Brexit the whole issue has again resurfaced. So quite honestly, by the time, if history goes any further, I think we really will have covered the subject and thrashed it to death. The idea is that, and I think it's a good thing to rehearse, the issues, because at the end of the day, clients want to know as objectively as possible what are the differences between the legal systems, without too much waffle and triumphalism and patriotism, that kind of thing. They really do want to know, and they need to know what the points are, so that they can evaluate them. And it's very important that we have to sort of convert ourselves to be comparative lawyers to give that advice. And frankly, although I mentioned there have been 3 peaks of discussion, it's a continual discussion which goes on every time you have a project or something. People do discuss this issue. So it's a well-trodden and routine path. Now, the way I look at it is that, in the world, and I've said this to many of you before, and I hope you pardon me if I mention it again, you've got three great families of law, which I call the English common law, the Napoleonic, and the Roman Germanic. And between them, they are the foundation of 85% of the world's 320 jurisdictions. And so you can say they have been phenomenally successful. And indeed, my view is that the planting of those legal systems, either by imperialism or emulation more commonly, was the biggest contribution which Europe has made, or one of the biggest, to the world. And so I think it's an amazing achievement. But in that achievement, there are enormous differences between these legal systems because of history. I don't think there are differences in present day culture between those groups in terms of what the populations think and feel. I don't believe in that kind of cultural difference, but I do believe in the very strong impact of history in crystallizing the ideologies of these legal systems, which I say are very different. The thing about the law, it has to make decisions, especially on bankruptcy, about winners and losers. And those decisions are very, very difficult to make. But the crucial thing to understand, I think, about the ideologies and the decision they make, it's not a question of one being morally good and the other being morally bad. It's not sort of wicked versus angelic. It's a question of, because most of the issues are a subject of reasonable debate on a spectrum. You can reasonably argue any of the particular points of view. So the issue really is, when you're doing a deal, what is the legal system which is most suitable for your deal, which involves an allocation of risks, because legal systems do allocate risks between the parties, and making a decision about that. For instance, legal systems have to decide whether they're going to back debtors or creditors on bankruptcy or in insolvency situations, and they have to decide about the role of very strict legal predictability versus palm tree justice and the merits and fairness and things like that. They're really fundamental decisions, and as I say, the decisions made are really quite different. You could say, and I mean this is an incredible generalization, that the English common law jurisdictions and the Napoleonic are probably the furthest apart, and then you have the Roman Germanic in the middle. And I suspect, without being able to prove this, that was because of the timing of the industrialization, the timing of the crystallization of legal systems in relation to the Industrial Revolution. Some people say, oh, there are other big factors, like whether it's professor's law or practitioner's law. Yes, maybe. I think there are a lot of variables involved. Now, at the moment, the position, so far as choice of law is concerned, for the big financial contracts, international bonds, syndicated credits, derivatives, ships, aircraft, and various long-term supply contracts, is that anecdotally, English and New York law have about 80% of the market. Now, nobody can prove that. That's purely anecdotal, and it may be different. The only thing is, I think there would be a general consensus that those two legal systems have a dominant position. And they are like an international public utility. So in England, the legal system doesn't belong to us anymore. It's used by other people who have nothing to do with England. And so the English, and to perhaps a slightly lesser extent, the New York judiciary have an incentive to make sure that they look after their franchise out there. And I think it's an important part of what is happening to these legal systems. They don't necessarily serve what the local population wants, because they are also having a regard to the international business community, who may have very different objectives. At the moment, there's quite a lot of competition, and we'll have to see how that plays out over coming years and decades. It takes a long time, I think, for a legal system to become established. Now, if you say, what are the points which are peculiar to the English legal system as opposed to the civil law systems in the EU? Now, I've got a list of about 25. I'm not going to go through all 25, don't worry about that. But that list of 25, I set out in a letter to a colleague, so Dear X, and that will be posted on the P.R.I.M.E website. So you can have a look at what I think the points are. There are only points which occur to me in my experience, and they relate mainly to the private law of financial transactions, not so much corporate law. You have different lists, or litigation, I think you've got different lists. Now, so I just mentioned a couple of the points which which make the English different from, say, the Napoleonic or the Roman Germanic, which between them are also different. And there's a lot of nuance, different nuances between European countries, including ourselves. The first is, as I've mentioned, is that English law is very familiar to markets, and there's quite a lot of inertia in markets. And because it's trusted, because of its background, it's been there for a very long time, people go along it because of the sort of inertia, you know. And it helps a deal that people feel you don't have to argue about that issue every time. The second thing is its language. It's got this mongrel language, which just happens to be a combination of the two main streams of European languages, the Romance and the Anglo-Saxon, which were brought to this country by colonizers, actually. It's what they left behind them. So you can blame them for the terrible spelling. And the fact that English is a language which is often used in international finance means that if you get into dispute, the law is more accessible. I don't think that's something which England needs to be proud of. It just happens to be due largely to the Americans. The third is, and this involves a choice of hard points on the law. The English policy is that it mixes freedom of contract with a high degree of a high policy of predictability. And this is sort of overriding that parties get what they negotiated, you know, subject to some very basic sort of human rights and unconscionability. So if a contract says banks can accelerate immediately on demand, that means 3/4 of an hour. And to some people that seems very harsh, but to others they say, well, even the strawberry picker who delivers strawberries to Tesco needs to have discipline in payment times, and you do need discipline if you're dealing with financial markets where there is a great deal of systemic risk. And the good faith or good morals or public policy argument in English law is very mild compared to what it is in civil code jurisdictions on the whole. Again, another excuse me, another quite big generalization. Now, a fourth factor is that English law is quite creditor protective. Again, you know, on insolvency, you have to choose the winner and the loser, the victim and the victor. It's a choice which can't be avoided. And that is shown by the triple priority of 3 super priority claimants, who are those with a set-off, those with a trust, and those with a security interest. And those are all systemic issues. I mean, something like a trust is systemic in the sense of very important custodianship, for example. Now, none of the EU civil law systems have all 3 with the same intensity as English law, though some of them have got 2 of them, and others have only got 1 of them. So those are sort of litmus tests which you drop into a legal system. And as I say, you know, you can definitely debate whether those are appropriate because they disturb bankruptcy equality, very obviously. But that seems to be the situation. The next point is that English judgments have a very high degree of recognition abroad. As you know, you don't actually need a treaty to enforce a judgment in most countries. A few countries you do need a treaty, but in most countries you don't, provided you satisfy various conditions which are usually quite easy to satisfy, things like reciprocity and due process and not for taxes and that sort of stuff. And a lot of work was done on that in the late 80s and 90s by the Americans, actually, because New York American judgments do not have that degree of recognition, mainly because of the US litigation system with its juries and so on. Then another factor is the insulation of the obligations of the of debtors from changes in the sovereign territory where the debtor happens to be domiciled. And that point relates specifically to a provision in the IMF agreements, which requires all member states to recognize the exchange controls of a member state, which is just about the whole world, except a couple like North Korea. And so that would enable a sovereign state to impose a moratorium on its loans and also the loans made to its banks and its corporates by imposing an exchange control. Now, the English, American, and Belgian court said, oh, that doesn't apply to bonds and loan agreements. But the German, French, and Luxembourg courts said it did. Now, of course, that case law can be changed, but nevertheless, if you're into the courts in France, Germany, and Luxembourg, that is a risk that you have to take into account, that the insulation may be lost by an exchange control. And again, it's not a killer blow. It's something which I think people who enter into contracts have to take into account. So, and then finally, I would mention that if the parties want English law with these various things which might suit their deal, it might not suit their deal because, if you're acting for a debtor, you might be better off with another system of law, which is more pro-debtor. So that is, something which has to be taken into account. But if you do choose English law because you like those points, then it would seem to follow you need English courts to back it up. Because if you don't have the English courts, you're going to get differences of interpretation, and also courts tend to apply their own conflicts of laws doctrines, which are very important in this field, and you might get a very unexpected result. Anyway, those are some points to bear in mind. They're all very debatable, and as I say, you can read about them in very concise bullet form in these 25 points, only 3 or 4 pages long. So thank you very much for listening to that. And so at this point, perhaps Guy, I'm sorry, I think Carl, if I could ask you to now add a few words, please.
Yes, thank you very much, Philip. Yeah, I'm happy to be part of this panel as a maverick, so to speak, as the only guy from a civil law jurisdiction. I will address 3 points. The first is the role of the judge in this. Then the second is what I refer to as the importance of the social model of a given legal order and of the image of man, which is underlying a given legal order. And the third one will be a few words on the function of general clauses in the codes on the continent. Now I start with the role of the judge, and there, if we want to evaluate legal orders in order to choose the most suitable one, we probably have to be more sophisticated than you would think when reading the 25 points. That's not a criticism, it's, that's how life goes. For instance, Switzerland is part of the Roman Germanic legal family, but there are certain peculiarities which clearly distinguish Swiss law from other civil countries' law. And the most important one is certainly Article 1, Paragraph 2 of the Swiss Civil Code, which gives the judge the power and the duty to fill gaps found in the code. You don't find that in any other codification in the world. And the well-known former Supreme Court Justice in the United States, Benjamin N. Cardozo, stated, I think the tone and temper in which the modern judge should set out about his task are very well expressed in the first article of the Swiss Civil Code. Swiss judges are thus probably closer to common law judges than, say, their French or Italian colleagues or even their German colleagues. And I may add that this freedom doesn't mean that Swiss courts would be particularly inclined to interfere with what the parties have written in a contract. On the contrary, Swiss judges are more restrained than their colleagues in classic civil law countries. And as I will explain, this is a consequence of the prevailing social model in Switzerland. That brings me to this social model. If we ask, what is the role of the state in a given jurisdiction, then it has become rather clear during the COVID pandemic again that in Germany there is still a Hegelian belief in the state as the reality of the moral idea. And that is not the case in Switzerland, it's not the case in the United Kingdom, nor has the French concept of la nation ever been the only legitimate power adopted in these two countries. In 1915, during the First World War, German economist Walter Sombart published a book with the title of Merchants and Heroes, Händler und Helden. And he described the Germans as a nation of heroes, animated by primordial motives, and the English as calculating merchants. And if we were to transpose this juxtaposition to the Swiss, they would certainly be among the merchants, like the British or the English. And in fact, the money-mindedness of the Swiss has been described many times throughout history. The old saying during the time of the mercenaries was point d'argent, point de Suisse. Now, this attitude to money and wealth appears to be reflected also in England. Napoleon is said to have referred to the English as a nation of shopkeepers, and this remark was meant disparagingly. However, in reality, it is a backhanded compliment. And finally, there are parallels in the image of man. In both England and Switzerland, the courts assume that human beings are normal in the sense of reasonable, that they do not need utmost protection. And this is now important. That's not only relevant in B2C relations, it can also be relevant in B2B relations. If you imagine, for instance, that in Germany, contracts concluded between merchants are subject to the control of general terms and conditions, something which is not happening in Switzerland nor on the level of the European Union. And if this is criticized, it is defended with the argument that the results in Germany are equitable or just or fair. And that leads me to my third topic: what is the function of the general clauses in the codes? The codes all over Europe are full of general clauses such as good morals, good faith, good cause, public order, prohibition of abuse of rights, untimeliness, etc. And such provisions can be used by courts as gateways for certain socio-political or economic policies. If you look at the commentaries on paragraph 242 of the German Civil Code, which regulates good faith, they are several hundred pages long, and that means that there is ample room to interfere with the freedom of contract. The German Civil Code of 1900 was a liberal code, but then came the world economic crisis after the First World War, and the German courts used these general clauses to interfere with the freedom of contract. Obviously, that was necessary in times of inflation, but this then, was continued in later times. And if we take France as an example, you may be familiar with the 1964 Frühauf France case, when a subsidiary of an American corporation received a large order to supply trucks to China, and the American representatives on the board stopped this contract. The French court said this would be an abuse of law, an abus de droit, and confirmed an injunction issued by the court of first instance. This would be my few remarks. I hope I have been sticking within the time limit given to me, which were 8 minutes exactly.
Thank you very much. Tremendous discipline. I mean, always the Swiss also have a reputation for absolutely punctilious timekeeping, the greatest makers of watches in the world. So you've maintained the reputation. Thanks a lot, Carl. So Guy, could you take the floor now, please?
Thank you very much, Philip. Good afternoon, everybody. Very nice to be with you. I want to talk a bit about legal platforms as economic tools, and to ask why they're not often considered or analysed in this way. So let me start with some general context. The choice of law in modern parlance means choice of an operating platform for a transaction, a commercial venture, or a series of them. And it's probably a bit like choosing an internet search engine or a social media platform. There may be a range of platforms available. The choice of platform has consequences because different platforms offer different outcomes. Now, businesses interact primarily through transactions, which are contracts. That's how they effectively speak to each other. Every contract will have a governing law, and the participants will have selected one, even when they do so involuntarily and don't realize that they have done so. Now, this makes legal platforms highly significant economic tools, both locally and globally. They're significant because they affect the ease with which business can be done, the cost at which it is done, the friction costs of transactions, but perhaps most importantly, they affect the risks which doing business creates. And so why, I wonder, are they not viewed as economic constructs? And why do risk assessments by regulators and market participants often, not always, but often not focus on choice of law as a major risk factor when set against credit assessments, for example? It's presumed, I think, that it falls into a different category, but this seems to be rather odd and something which should be challenged. But I think actually it's part of a wider set of challenges which range, for example, from a localized question. This will relate locally to everybody wherever you are. Why is social welfare law not viewed through an economic lens? It frequently isn't, but it's simply an economic issue. It's how do individuals use the law to make their lives better and to prosper more? But often it's set into a different category from other forms of economic influence on their lives. Then to a global one, why, for example, do rule of law factors not feature more heavily in credit rating agency assessments of sovereign debt? These are, I think, all part of the same issue. Now, those particular questions needn't detain us today. It's the question of legal platforms in commercial markets is more than enough. But I think the point I make is they all reflect the same blind spot. Legal systems frequently are actually only evaluated in economic terms for the purposes of competition law. But competition law is meant to stop us doing things. They're rarely viewed as important economic tools in themselves for the creation of prosperity. Yet the economic significance of legal systems is perhaps most evident in financial markets and the choice of legal platform which those financial markets make. So this all goes, I think, to the point about English law in particular, but any legal system as a national asset. Now, the issues arising from choice of law are not in themselves obscure ones. They can be complicated in how they apply to particular circumstances, but they're factors like netting outcomes, reliability of trust structures, certainty of contractual provisions. Philip's got another 22 on top of those. And he can talk persuasively and authoritatively about them, but they're not shrouded in mystery. But it appears, particularly in the post-Brexit context, that financial institutions can take decisions relating to governing law on seemingly politicized or partisan grounds. But everybody knows that for a marketplace as a whole to have global credibility, risk analysis needs to be insulated from political interference. But one of the consequences of Brexit seems to be that financial institutions and regulators appear to be forgetting this golden rule. And that's not of itself a partisan point. It actually goes to the credibility of European markets, taking European in its widest sense, in the eyes of the rest of the world. So let me return to my earlier underlying question. Why are legal platforms not recognized as significant economic tools and analyzed in that way? Well, in the United Kingdom, the City of London is a driving force economically. It's not necessarily a fashionable one in times of leveling up, but it remains a driving force economically. But analysis of why the city has become an important global hub is interesting because it touches on a number of soft and hard factors. And true, it will nowadays have a reference to legal services and lawyers as part of the working ecosystem of the city. But it will rarely reference the actual legal platform offered by English law. There may be references true to the independence of the judiciary, but key economic issues like the ability to create, adopt, and adapt to new financial markets and instruments, the attributes of certainty, the role of trust-based structures in creating new instruments, these are rarely mentioned. So this oddity of including references to legal services and lawyers, but not recognizing English law as an operating platform for markets should be set in context, because I wonder what would be the reaction to an analyst who offered an assessment of Google by referencing the activities of software engineers. That's what even the home team in the United Kingdom are doing. They're not recognizing the legal platform as an economic tool. And such a response in relation to Google would be ridiculed as inaccurate. So why the blind spot on legal platforms when all other forms of platform and infrastructure, internet, transport, communication, appear increasingly to be recognized and valued both financially and socially? Now you might ask, well, why does this matter? But look at the development of financial markets over the past 70 years. And Philip referenced this a little. Which legal platform hosted and drove developments on Eurobond markets, structured finance markets, securitization markets, swaps and derivative markets, and a number of others? Is that a coincidence? Now, the ability of English law to provide an operating platform which could both develop and adapt to innovative products and practices has been of huge significance, but it doesn't appear to be recognized as an economic asset. And then consider the next 20 years. Well, we can already see green finance, smart contracts, the adoption of AI in contracts, ESG-based financing, all looming into view. And there will be a host of other changes and innovative products which we cannot yet see. Now, markets should be evaluating the legal platforms on which they plan to rely to see whether those platforms can cope with the likely pace of change. So there does seem to me to be a major blind spot on the part of markets, regulators, market participants on this fundamental issue. And it's not a partisan criticism. Yes, I see EC financial institutions seeking major shifts in legal operating platforms without paying heed to the consequent economic risk. But I also see UK institutions who appear not to understand the need to develop a legal platform which can adapt to the next phase of change. So nearly all the participants in these decisions have fiduciary duties of various kinds. It seems to me that ignoring the economic significance of choice of legal platform does not square with those duties, and it's time, in simple terms, everybody woke up to this. So let me briefly conclude. The topic on which I'm going to be talking is English law as an asset. English law is a very curious asset because, first of all, Philip hinted at this, no one owns it. So developing it and using it and making sure you use its full potential is challenging because nobody owns it. Second, its brand attributes, because many purists won't like this, but I think it is a powerful brand, might best be summarized as independence, certainty, fairness, and clarity. So if you're looking for a brand champion, you can't have people who profit from it So you can't, I think, have practitioners, and you can't have governments acting as brand champion because they have a conflict. They won't be trusted, and the brand values, the leading brand value is independence. And thirdly, it now has a number of other jurisdictions that appear to recognize the value of legal platforms as economic assets to a greater degree. And so there are challenger and competitor jurisdictions there. So all those things make the question of what is the potential of English law as a national asset a very interesting one. A more interesting one, though, is what do you do about that potential? And I will stop there for.
Okay, thank you very much. Some very, very interesting and profound thoughts, Guy. I'll come back to that in a minute, if I may. But Carl, if I may bring you in again, do you have any comments on what Guy is saying there? And perhaps at the same time, I wonder whether, and I know these are two separate points, whether you might comment on why you think English law has a stress on predictability, which is less valued in terms of contract, it would seem, because of the fact, the good faith and other doctrines. How that has happened, why legal systems have drifted apart, in your view, as a judge?
Yes, well, I think that the decisive question here is whether courts are inclined to interfere with the will of the parties in the interest of certain goals, societal goals. You mentioned human rights, all sorts of other issues which can come into play. And there, I think, as far as I can see now, not being an English lawyer, but still having worked with English lawyers quite a lot, that English judges are rather inclined to stick what the parties in commercial contracts at least have agreed, whereas judges in France or even in other jurisdictions may be inclined to interfere with that. I want to make two additional points when it comes to differences between the judiciaries. One is that on the continent, there is no real system or doctrine of precedent. And even if in England or in the United States, the doctrine of precedent doesn't mean that the court cannot deviate from previous case law, they have to make it clear that they have deviated. That means they have developed this art of distinguishing, and this art of distinguishing is good for predictability and for legal certainty. If you take civil law courts, also the Court of Justice of the European Union, they may deviate from previous case law without indicating that they have deviated and where they have deviated. And that is probably good for certain lawyers, but it's not good for predictability. The second difference I see, major difference between the English system and, say, the German system, is that in Germany you have the career judges. People join the judiciary at a very young age, basically after having left university, and then they climb up the career ladder. If everything goes well, they will end up on the Supreme Court. And in Switzerland, that's similar, but in Switzerland, you have political elements which are addressed openly. In Germany, the assumption is that judges are free from political influence, whereas in Switzerland, judges run for office based on party affiliation, political party affiliation. I was always very critical of this, but over the years, I have started to think there's also something about disclosing this, that a judge is running on the platform of the socialists, or another judge is running on the platform of the conservatives. And importantly, also in Switzerland, judges are only elected for a term, not for a lifetime. In Germany, the judiciary was deemed to be unpolitical after the Second World War for good reasons. But in recent times, we have seen a certain tendency of politicization of the courts. In Germany, there's a huge debate about this up to the Constitutional Court, and that's also not good for legal certainty and predictability, and leaving the contracts in the hands of those who have formulated those contracts.
Thank you very much, Carl. I think those are very perceptive and interesting points in the comparison of judicial careers, and help to offer some explanation of why one does have these differences. It used to be celebrated in the old aphorisms, you know, pretty much on the lines of the calculating merchants. That you know, English law is practitioner law, made by practitioners, these dull plodders, you know, who just do deals, as against professors' law, more spiritual and moral, which was often an ascription ascribed to German law. I don't know whether those stereotypes are still true.
Well, there's something to that. There is something to that, no doubt about it. And you know, Swiss law was also practitioner's law. And if you read the Swiss Civil Code, it's rather untechnical language. You know, the ideal was that the ordinary man, nobody spoke about women at the time, the ordinary man should be able to pick the code from the shelf and understand it. That was the ideal. Now, in the meantime, it has become more complex, clearly, and there are a lot of German professors teaching in Switzerland that they bring their way of thinking with them, so that they also have an influence on this development. Quite clearly. There may be another important issue if I say that there are certain parallels about the English way of dealing with the law and the Swiss way of dealing with the law. That's probably religion. It probably is so that the Calvinist doctrine of wealth, which has originated in Geneva, has come to England and from there to the United States. And in other parts of Europe, this is missing. That God loves you because you are creating wealth, you know.
Yeah, I must say, I do like these broad cultural views. Very, very, very useful. That one sometimes does have to stand back in that way. Guy, if I may return to you for a moment, you were discussing, you know, the risks posed by legal systems, and I think really that's a very insightful thing, which is not generally brought into account. How do legal systems allocate risks, and what risks do you take? And I suppose my comment will be, and I don't know whether you would agree with this, that the problem we faced with is that it's very difficult to measure the impact of legal doctrines upon economic differences. Or it seems, and I think the reason why it's difficult is that you really have to be a very knowledgeable comparative lawyer in order to make that comparison. I mean, let's just take one example, which I mentioned earlier. Something like insolvency settle, which, by the way, is the governing law is very important in deciding whether you get it or not, because in many jurisdictions, including Europe, you get the insolvency settled if the debt owing to the insolvent is governed by a law which allows insolvency settled. It's one of the chinks of light in the mandatory compulsion of insolvency law, allows parties to choose their insolvency law, which is an amazing thing. But that's one of the reasons why choosing the governing law is quite important if settle is important in your particular context. So in that kind of case, I think you can actually measure the fantastic difference which something like netting makes upon economic advantages and disadvantages. And the scene is complicated much more by the fact that very many countries have got carve-out statutes where they allow set-off and netting for financial markets, but not anywhere else. Whereas England's difference is it's universal. You're allowed that universally and you don't have to have a carve-out. And so it's quite a complicated analysis. And similarly, the analysis of security interests. You know, the English are famed for their universal fixed and floating charge, which grabs up monopolistically all of the assets of a company, the theory being, I suppose, that it reduces the cost of credit and the bank stays longer with the situation than otherwise it would. All of these things are very difficult to measure, actually, and very few studies have been done. I feel that if ever there was a really interesting job for academic comparative laws, it is focusing on points like this. But I'm sorry to say, on the whole, I don't think they are for some reason. I don't know what you think of that question of measurement.
Then not, I mean, the point, your starting point related to complexity of analysis, which is true up to a point. But if you look at other areas of risk assessment, if you look at cybersecurity, well, how many of the people who are actually taking policy decisions in relation to cybersecurity really understand the reasons why their systems may be vulnerable to penetration from fraudsters using very sophisticated techniques? They don't understand that. There's a whole series of, if you look at credit assessment in other areas, there will be a series of algorithms which are used to determine what the level of risk might be and to compare different types of risk. So the complexity is there across the waterfront. And I really do not believe that the legal issues are more complex. I'm certain they're not. They're neither more nor less. But what is absolutely true is where you finished. There is very little research on this. And it goes back to, I think, the inability of economics and the law to recognize that they're two different sides of the same thing. They are very heavily linked sciences, and but there's very little overlap. And you tend to see that if you take it to a more domestic point of view. Now, I don't know what the position is in other jurisdictions, but in the United Kingdom, if you look at the application of the legal system, particularly the criminal justice system, but also civil side as well, as it applies to citizens, there's no data. Well, why is there no data? Well, partly because nobody really wanted to study it. So no one has said for years and years, you need to have it. So we don't have any, but we have no tradition of understanding, studying and developing the economic side of the law. Partly, I think, because people have viewed it really as a slightly inferior use of their intellect. And so you have this slightly odd situation where elements of the law, people say, well, that's bloody difficult, we'll bring in a lawyer to deal with it, and then we'll turf the lawyer out and we'll take a decision, which is a hugely dangerous way of approaching things. So you've got this slightly odd sort of academic background to, I think, the absence of economic analysis of the law in certain contexts. It's no more or less difficult, I think, than other contexts, but it's a great failing that it hasn't been done. What amazes me is that people at the head of very sophisticated financial institutions haven't recognized this. And they tend to say, well, so that's the law, as if, well, that's Urdu, I don't speak it. Quite bizarre. So there is a big problem there, and it's going to get worse because as markets develop, you get far more virtual reality in financial markets. You'll get all sorts of, it goes way beyond sort of derivative instruments. You get cryptocurrencies, and you'll get sort of mimicked reality in different areas. And so you're going to need to marry the ability to make very complex economic analysis of outcomes using legal tools. It's got to be done. And it needs to be done quite swiftly, I think.
No, I agree. I mean, I agree that it's something which is really important. I'm a great believer. I don't think law is just a technical subject. I think it's the foundation of our society. You can't really have a modern society without a legal system which includes the law relating to money, banks and corporations and so on. But I think that the fact is, as you say, that the regulatory codes, practically every line, deals with risk. And so it is indeed a surprise that this is not so much on the agenda. And certainly corporate codes with all of their rules about good governance, especially in the twilight zone, when hovering on insolvency, is also hinged, it's keyed in to the risks which are taken, of which the legal system is if you like, the moral and ethical framework of our society has got to play a major role. Anyway, I think there is a gap.
But Philip, if I'm allowed to intervene with one other enthusiasm of mine, it relates to the fragmentation of risk, because people find it very, very difficult to take sort of full picture analysis of risk. So financial institutions sort of had no real understanding historically of their sort of absolute net position. What regulators do is fragment risk. They divide it up. And so, they'll give party analysis to one person. And this is the whole point about non-executive directors, which seem to me to be the most awful way of dealing with risk. Actually, the only way you really deal with risk is make executives more accountable. You don't create huge swathes of other entities that you can blame, throw elements of risk over to, because that means nobody's on the ball. And if you look back, essentially, the whirlwind has been reaped from that many times and will be again. So the fragmentation of risk is the normal regulatory response to things which they believe seem to be too complex for anybody to understand a holistic way. That problem has not gone away.
Thank you very much, Guy. Camilla, I think probably that it's time for questions. Are you there, Camilla?
Here I am, Philip. Here I am. So we have a question straight to you, Philip. You're in the hot seat, about contractual interpretation. How do you think the shift from the Hoffman approach to contractual interpretation, including references to matrix and generally a more wide-ranging approach to intention and business efficacy, to the more recent approach of the Supreme Court under Neuberger, reverting to a much more literal approach, has affected certainty in English contractual interpretations?
I mean, I think my reaction to that is that the differences are really quite fine and narrow. And although, if you're an ideological purist, you make much of slight deviations from a classical norm. I don't think the Neuberger versus Hoffman dispute affects to any really significant material degree the overlying, the consensus of the English judiciary about predictability and about the role of the good faith doctrine in comparison to other legal systems, which do invite a considerable latitude, as I think Carl has vigorously and convincingly pointed out, do invite considerable latitude in the judiciary to reform contracts in a way which can be quite dramatic to the parties involved on the basis of what they think is fair. And English law, I think, is a bit of a on its own in that respect, because New York law itself has a very strong doctrine of good faith, which is applied to things like eventual default and terminations, range of liability, and all of the contract disclosure, the whole host of things which are encoded now in the new French Civil Code. So I think New York law can get by without that, with that point, and with the point that its judgments are not all that welcome around the world, because it's such a massive market, and people are very happy to contract on New York because it's the leader of this huge market, has massive market appeal. So I don't particularly think that that's a major factor. But thank you very much for the question. I think of course, it's a matter of great debate which way English law will go on these issues, which I'm talking about now, because legal systems never stand still. They compete with each other. They certainly don't stand still under the pressures of the competition. Thank you for the question.
All right, we've got a few questions coming in. This is an interesting one about proposals to harmonise contract law at EU level. So that was something people were talking a lot about a few years ago. But should we be now looking at pushing English law for international finance and international trade? Or should we be trying to get some elements of harmonisation on contract and financial legal matters in wider global network to support business? Do you have any views on harmonisation on contract? I don't know if Philip wants to take this, or whether Guy has any thoughts on that also.
Go ahead.
Well, the only thing that, yes, this probably may not be the optimum time at which to press English law in a more competitive way internationally. The only comment I would make is that having been senior partner of a law firm, 400 partners, if you want them all to think the same way, the last thing you should do is tell them how to think. So the real issue going forward is not, I think, to try to persuade people, because there'll be valid arguments in both directions, to consciously to also sort of cleave to the same legal operating platform. The real challenge is how do you demonstrate that you have a platform which over the next 20 years is quickly going to be able to adapt to cryptocurrencies, smart contracts, the use of AI, and if any legal platform which actually demonstrates that it's got the ability to accommodate those things and has processes for adapting to them, will then, that will give you all the harmonizing you need, because that will actually be the platform of choice. So now doing that how you do it is a completely different issue, because you'd have to have a lot of additional processes and ability to actually preempt changes compared to what you have now. But that would be the way, because it's, as always, the most interesting time in life is the period which is about to unfold. And you know, that is going to be a period of enormously swift change. So that'll be the key, as to what platform can react to it.
Thank you. Are there any other questions?
Yes, I've got one which I believe has come in from Switzerland, and very interesting it is too. So it said that English law is highly predictable, but it is case law, and cases are hard to look up and can always be distinguished if you try hard enough. Why should English law have an advantage on predictability as compared to the liberal and easy to read Swiss codification? And our questioner goes on to say that when I ask an English solicitor a question about English law, they usually first need to turn to QC for an answer. And I've been in that position many times myself, so I'm very interested to hear what you have to say. Maybe Philip could have a view and Carl add something thereafter.
No, I think this is for Carl, maybe. I think it's a very good question. Terrific question. Carl,
well, yes. Yeah, this is a valid point. Quite clearly, I think under the English approach, on the common law approach, predictability is guaranteed by the system of precedent and the art of distinguishing. But it is not easy to know the case law. That's quite clear. On the other hand, if you have a codification, it may look easy at first sight, but then at the end of the day, there's also a lot of case law which you have to know. So it's probably challenging under both systems. I remember when I was teaching at the University of Texas, I wrote an article for the Fordham Journal about the differences between the common law and the civil law approach to these matters. And I was flabbergasted that my American colleagues started to speak highly about codification, because codification would guarantee predictability. I think at the end of the day, it's not so much whether you have one or the other technique. It's more about what I refer to the social model, that you believe in a liberal contract law. And if you believe in a liberal contract law as a judge, you will be less inclined to interfere with the contract, with the content of a commercial contract, than if you believe in a more interventionist model, where you think, well, you know, I believe that this is not just, this is not fair, this is not equitable, and that's why I have to make an intervention. I mean, if you have to go to a French court in certain parts of France, you may be faced with judges who are members of the communist magistrat syndical, which is a labor union, and such judges may then want to bring in their socio-political and economic beliefs. So at the end of the day, I think the decisive difference is whether you have a certain tradition of market orientation and shopkeepers in England and l'argent en Swiss. That's probably more important than the other differences.
Thank you very much, Carl. Camilla, I'm conscious of the time. The clocks are ticking on. It's on 6 o'clock now in London. So I think we probably reached the bewitching hour, have we not? We
have reached the witching hour. Let me just conclude with just some thanks, if I may, to all of our speakers, Philip, Guy and Carl. It was really a terrific session. I was so pleased that we were able to host it. Philip mentioned his list of points. We'll put that on the P.R.I.M.E Finance website in the next day or two. Now, this is series 4 of Prime Time. Our next session in this series is a conversation with World Bank General Counsel Sandy Okura, so please do join us, and the sign-up link is appearing in the chat box now. And if you're interested in sponsoring an event, please get in touch. I'd like to thank FTI Consulting, McCann Fitzgerald and Travis Smith for sponsoring this series of Prime Time. And thank you again to Lexis for their support. Finally, P.R.I.M.E Finance accepts donations through Friends of Prime to support its work. If you'd like a donation or to find out more, please get in touch with us using the details showing in the chat box. So all that remains is for me to thank you all very much, and thank you to all our attendees for joining us. Thank you. Goodbye.